Hello everyone, just a brief overview of the three cases referred to in Bulletin 35. The first was a case of Lewis and Lewis, which was not a typical situation we encounter, that is of an estranged son who returned to the family fold and basically took charge of his mother's affairs and dictated effectively the terms of her will. And when she passed away, the siblings of the gentleman concerned said that a number of things. They weren't obviously happy with the outcome of the rearrangements and the terms of the will. The first was whether the mother had capacity, and she was found to have testamentary capacity, but when it came to knowledge and approval, the court was not satisfied that she understood the complex rearrangement that the son had attended to and the way that he had orchestrated his control effectively of his siblings' affairs. It was important to note, I think, that the solicitor who had taken instructions from the son about the mother's will and the affairs, the rearrangements generally, of course, it was not found that he had actually explained the terms of the will to the mother, and that was obviously quite telling, and therefore she lacked knowledge and approval. As a result, various sections of the will were not granted probate of, and they were therefore excluding the provisions that enabled the son to have control of his siblings' trusts and various other matters, exempting from a certain clawback provision that they were subjected to, etc. So I think it's an interesting case from that point of view of the role of a solicitor there in making sure the client understood, even though she had capacity. The other case is one on executor's commission. The agreement to pay commission was not a problem. They agreed, the residuary beneficiary agreed, or residuary beneficiaries agreed to a $10,000 payment for executor's commission, but obviously they suffered some shock when they realised that the legal fees in a $480,000 estate were in excess of $268,000 or thereabouts. So far more than half of the estate had been eaten up in costs. They asked for the passing of the accounts, and the registrar refused to pass the accounts on the basis other than that the administrators refund to the estate around $30,000 in the legal fees that they'd paid. On appeal from that decision, Justice Hallen made some interesting remarks that I think are worth noting. The first was that the administrators had not, and I think this was a comment generally by the registrar as well, but the administrators had not turned their mind to the question of the charges being reasonable and proportionate in relation to a very modest estate. The other issue was that in moderating the fees, which the registrar was empowered to do, that there had not been an issue about whether the administrators, or the issue was not for him or her to consider what the reasonableness of the fees charged by the administrators to the administrators by the solicitors they'd engaged, but rather what of those fees were properly payable or to be borne by the estate, and that was the issue. So it's a timely reminder that administrators, executors, especially in this context, well, in any context, but especially in this context of executors' commission, have to be very mindful of making sure that the fees they're incurring are proportionate to the size of the estate, and also to ensure that what the estate is to bear are properly payable by the estate. The final case is a family provision case, and it was really a situation of an appeal because the primary judge had ordered there was a legacy of $10,000, and the primary judge had ordered that be lifted to $100,000 and it be paid out of the notional estate of the deceased. There was a joint tenancy that passed to somebody by survivorship, the respondent in fact, and the issue of paying it out of that was not a problem, but the appellant, the original applicant, was not satisfied with getting $100,000 and appealed. A couple of comments made in that appeal by the Court of Appeal I think are worthy of note. The first is that they didn't consider that the primary judge had erred in taking consideration the impact of taxation on the respondent if more than $100,000 was required to be paid. It meant that he had to sell property that he relied on the income from and pay capital gains tax and so on. And that was taken into consideration, and the Court of Appeal said that was a fair enough consideration by the primary judge. The other remark that I thought also was particularly of interest was this, and they agreed with the primary judge on this observation as well. A parent would not ordinarily be expected by the community to provide an adult child, especially one in her 70s without a disability, which was the situation in this case, with unencumbered accommodation. There was no expectation that that should be the case. This particular appellant, the original applicant, lived with a daughter, and so those remarks have got to be viewed in the context that she was in her 70s, she was living with a daughter, and the judge made the remark, and the Court of Appeal agreed that it was not ordinarily the expectation of the community for such an applicant to be given unencumbered accommodation. Thank you.